This post discusses another proposed family law bill under consideration during the 2024 Utah legislative session. It's House Bill 157, entitled Child Custody Factor Amendments. This bill, if passed, would provide that a parent's approval or disapproval in itself of a child's gender identity is not a factor to be considered, 1, in a Division of Child and Family Services determination regarding removal of a child from parental custody, and 2, when determining child custody as part of a divorce or other family law proceeding. If passed, House Bill 157 would amend Utah Code Sections 30-3-10 and Utah Code Section 80-2A-202. The new provisions specifically are, for Utah Code Section 30-3-10, the following change in subsection 10, quote, in considering the past conduct and demonstrated moral standards of each party under subsection 2D or any other factor a court finds relevant, the court may not, b, discriminate against a parent based upon the parent's agreement or disagreement with a minor child of the couple's, Romanet 1, assertion that the child's gender identity is different from the sex assigned to the child at birth, or 2, practice of having or expressing a different gender identity than the sex assigned to the child at birth, close quote. The change to Utah Code Section 80-2A-202 would be as follows. Quote, B, a peace officer or child welfare worker may not take action under subsection 2A solely on the basis of a parent's agreement or disagreement with a minor child of the couple's A, assertion that the child's gender identity is different from the sex assigned to the child at birth, or B, practice of having or expressing a different gender identity than the sex assigned to the child at birth. Close quote. Abraham Lincoln said, quote, how many legs does a dog have if you call his tail a leg? 4. Saying that a tail is a leg doesn't make it a leg. Close quote. While I realize that the intent of this bill is not to give credence to, among other things, all of which are bad, junk science and the extremely dangerous notion that one can legally force others to share and engage in one's own delusions, the result of enacting such legislation would, ironically, have the opposite effect. In other words, the bill incorporates sex assigned at birth, for example, when biological sex is not assigned. But a law like this would legitimate this inanity. The best way to deal with what will be looked back on as one of the most intellectually bankrupt and embarrassing concepts of the 21st century is to give it precisely all the statutory attention it deserves. None. Parental rights are inalienable and God-given, not a thing the government can erode with trendy, woke, there I said it, legislation.